Hello friends, today we're going to honor all of the United States veterans from the 6 different branches of the military in this country. I personally want to say thank you all for your service to this country. I grew up with family that also served in the military. My dad served in the Korean War. I have a brother and an uncle who served in the Vietnam War, and I have a cousin who served both in Desert Storm and Desert Shield, and I thought that the best way to honor all of you is to make a video on the nuances involving divorces for the military personnel, whether they be on active duty or reserves. I thought this may be some good information because we do represent a lot of veterans. So welcome back to the divorce broadcast. My name is Manny Segarra, coming to you from Miami, Florida. Alright, so some of the nuances and issues relating to divorces that involve military personnel can be a little bit complex. So let's jump right into it, starting with jurisdiction. And what I mean by that is, where is the divorce suit going to be filed? What is the jurisdiction? What state is that divorce proceeding going to be filed in? Well, it can be a little bit complicated, especially if the service member is stationed in a different state or somewhere overseas. In most cases, the state where the service member either has a legal residence or a domicile, think like their home, think like what their driver's license says as an example, has jurisdiction over the divorce. That means that these places where the service member has either a domicile, residency, or is permanently stationed are known as the home state. Even if the service member is stationed in another state temporarily, the home state usually retains jurisdiction over that particular service member. Remember that when filing a divorce, you also have to account for the Uniform Child Custody Jurisdiction and Enforcement Act. It is a form that needs to be filled out. It's called the UCCJEA. That form has an exception for service members when they're stationed in a different state, so be aware of that, as well as the parties can consent or they can agree that a particular state has jurisdiction so that the suit can be filed in that particular state. Remember that there are some very important federal laws that are enacted that provide protection to some of the service members. First one that we're going to mention in the video is the Service Member Civil Relief Act, also known as the SCRA. It is a federal law enacted to provide protections and financial relief to active duty members of the United States military. The SCRA is designed to ensure that service members can focus on their military duties without being unduly burdened by court proceedings. And it's also important to note that the SCRA only applies to active duty service members. So let's talk about some of the provisions, starting with the SCRA allowing for active duty military members to file extensions and prevents courts from entering final orders or final judgments on certain legal matters until the service member can be present. The SCRA also allows the military member to request a stay or a postponement of certain proceedings, including divorce proceedings, until they can be present or until their military service is completed. The SCRA also requires that the service member receive proper notice of any pending legal actions, including actions of dissolution of marriages, and it protects them from having defaults entered against them. The SCRA also indicates that the state of legal residence for the service member always has the authority to divide the military pension of that service member. So very important protections under the SCRA. The other big federal law that interplays with divorce proceedings is called the Uniformed Services Former Spouse Protection Act, otherwise called USFSPA. That is a federal law that addresses the division of military retirement benefits in divorce cases involving military service members and their spouses. The USFSPA was enacted in 1982 and provides guidelines and protections for the division of military retired pay in all types of divorce proceedings. Let's now talk about some of the key aspects of the USFSPA. Let's start start off with the marital property. It designates a military retirement payment or retired pay as a form of marital property that can be divided between divorcing spouses. So that's a little bit of tough news for the military vets. That is the federal law that grants your divorcing spouses, anybody who's a divorcing spouse, the ability to get a piece of the retirement pay. They have to qualify under what the US FSPA indicates is the 10-10 rule. The marriage must have overlapped with the service member's military service for 10 years. If the marriage meets the criterion for the 10-10 rule, then the Defense Finance and Accounting Service can make direct payments to the former spouse. The US FSPA also allows for state courts to determine how military retirement payments should be divided. That means the amount, like what is the percentage of the division rate. So be on the lookout for that. In addition to this, the US FSPA does not mandate a specific duration for these military retirement payments to the former spouse. The federal law allows for the state court to decide whether the former spouse is entitled to the portion of the retirement pay for a set term of years, for life, or until some other triggering event occurs, such as the death or remarriage of that former spouse. Additionally, the US FSPA also addresses the survivor benefit plan, which provides a portion of the service member's retirement pay to the former spouse in case the service member passes away. The law allows for the state court to require the service member to elect the survivor benefit plan coverage for the former spouse, with the cost being shared between both of the parties. Now that we have discussed how some of the federal laws impact some of the divorces involving military service members, let's talk about some of the other nuances, including free legal services. Yes, service members and their spouses can oftentimes access free legal assistance on military bases. I suggest that's a great place to start because they'll get free advice on how to navigate the issues involving a divorce. This can be very valuable in navigating the complexity of these types of military divorces. Next up, we're going to talk about parenting plans and time sharing schedules. In the past, it was way more difficult for active duty service members to be awarded either primary custody or a significant time sharing of a minor child. However, today there's been a change and a trend at getting both parents equal time sharing or significant time sharing with the children. As all of you know, if you've seen my video before, in Florida, the presumption now is equal time sharing. So states are now more often to focus on the overall best interest of the child rather than to automatically say, oh, this person's a service member, they can't have time sharing. So obviously the court will consider whatever the statutory factors are of that particular jurisdiction. We do have to be cognizant of the upheaval of a parent who lives in a totally different part of the country because they're stationed there. So physical custody and time sharing with the children can be difficult, but remember, there's always summers, there's always the holidays. The military service members have leave where they can get off the base and visit with the children. So time sharing schedule can obviously be worked out. The parties will probably have to be a little bit more creative. Remember also that the SCRA, which we talked about in the beginning, allows for military members to delay these proceedings. So in a custody related matter, maybe the final adjudication of child custody or the time sharing schedule and corresponding parenting plan may not be addressed. Maybe they'll be bifurcated, but one thing is for sure, that the military member will eventually have all the rights and access to a child that the other parent will have, or at least the opportunity to be heard before a court. It is also important to know that once that military member is no longer on active duty, or maybe they retire from the military, when they move in their post-military life, they will always be able to modify the time sharing schedule. So always keep focused on the fact that these things are fluid and they may change over time. All right, so besides the child custody issues, the other big ticket item is the equitable distribution of property, especially when they involve military families. It essentially works the same. Whatever the statutory framework of equitable distribution is in a particular state, you would follow the same thing. However, the big fight is always the military pension or the military retirement pay. As we already mentioned, the SCRA says that the service member's state of legal residence residence always has jurisdiction to divide the military pension, and that's the big one. Whenever I get a service member who comes to meet with me and asks me to represent them in a divorce proceeding, it's always one of the first questions, especially if they don't have kids. What's going to happen with my pension? Well, what's going to happen with your pension is that the state law controls whether or not the former spouse is going to be entitled to your pension, how much, for how long, things like that. So you have to check your local jurisdiction to see what the equitable distribution rules are. But yes, your pension is up for grabs. As I also mentioned before, it really depends how long the service overlaps with the length of the marriage to see who is going to pay it. If it is a marriage that lasted 10 years and the service lasted 10 years, then the payments are going to be made directly by the federal government. However, if it's a little bit less, then the payments are going to have to come out of the pocket of the military spouse, and they might have to pay the former spouse directly. So we need to keep our eyes on that. If you're a military service member, you're starting to get a little depressed at this part of the video, take solace in the fact that there are some parts of the pension that are non-marital. This means that anything that was earned outside of the marriage is non-marital, non-divisible property. So that means that anything that you earned before you got married and anything that you earned after the filing of divorce remains out of the pot for equitable distribution. And there seems to be some other certain examples of items that may not necessarily be part of equitable distribution, including any type of VA disability compensation, any combat related special compensation, as well as most military disability retirement payments. You should, however, check your particular state and jurisdiction, because some states don't account for those types of payments. So each jurisdiction is different. So make sure you check that out before you go celebrating that your spouse isn't entitled to a portion of your retirement pay. One of the areas that also may be a little bit tricky to navigate is the spousal and child support provisions of a divorce involving a military service member. Oftentimes, these military service members end up having to pay support pre-divorce through their particular military service. Each service has its own policy, so you gotta see what they require, what's included whenever there's a divorce filed in your particular branch. And these policies are often designated to be temporary. So ultimately, when the court decides it in divorce court, that is what the permanent orders are going to be. But actually calculating child support and alimony can be challenging because the military pay includes certain allowances and special payments, as we just mentioned, that aren't necessarily counted as income pursuant to some of the state child support guidelines and federal law. In the event that there is a determination of child support, there is also a cap. Divorce paychecks deductions for child support and alimony cannot exceed 50 to 65% of the service member's disposable income. If the court-ordered support is not greater than the maximum percentage allowed, then the entire support payment can be withheld from the service member's paycheck. You would have to send a copy of either the income deduction order or whatever the order is requiring child support directly to the Defense Finance and Accounting Service, so that whenever the service member gets paid, the spousal support, alimony, and or child support will be deducted automatically. Alright, so before we wrap this video up, a couple more effects that the divorce process has on families that involve military service members. First, after an entry of a divorce judgment, oftentimes the military service member will lose their installation family housing. Usually it's within about 30 days, a couple months max, in which they will have to move to a different location because they lose that family housing. In addition to this, the military may oftentimes pay for moving expenses of the non-military spouse. The divorcing parties can also negotiate moving costs if the base does not cover it. In addition to that, the former spouse may lose the health care benefits. It's called the TRICARE. TRICARE is the health care program that provides medical and dental coverage through eligible members of the United States military and their families. As I just mentioned, the former spouse of the military service member may lose their health care benefits after the divorce. That former spouse can, however, check and see if they may continue their health coverage, if they qualify under what's called the 2020-20 rule or the 2020-15 rule. Essentially what has to happen is that the marriage between the military service member and that former spouse must have lasted 20 years. The military service member must have performed at least 20 years of credible service towards retirement, and there must have been an overlap of at least 20 years between the period of marriage and the period of military service. If that is the case, then that former spouse can request to continue the TRICARE benefits. If it's not quite 20 years, then they can see if it overlapped by 15 years, and then they can extend the TRICARE benefits a little bit longer. I think it's like a year or so. So that's what the 2020-15 rule is. And that is a wrap on nuances and issues that are involved in divorces with military service members. Before we sign off, I once again want to give a heartfelt thank you to all of the service members and vets for your service to this great country. If you know anyone that may find this information useful, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video. Subscribe to the Divorce Broadcast and put in some comments so that we can respond to you. And we'll see you soon. Thank you.